Good morning and welcome to another edition of Legal Access. We get together each and every Thursday morning at 11:30 to give you access to different aspects of the law. Today we're going to be talking about criminal law. That envelops a lot of different things, specifics like DUI, drug charges, or anything as far as the legal system is concerned. Plea bargains, bail, bonds, anything that you have questions about. Today is the day to get those questions answered. So give us a call. The phone number's on your screen, 843-848-8080. Criminal law is our topic here today on Legal Access. And on the panel here today to answer the questions for you, to my left is Austin Thomas. Hey, Austin, how are you doing today?
Doing great. Thanks for having me.
And what is your law firm, and what else do you guys work with in addition to criminal defense?
It's Grooms and Thomas Law here in Myrtle Beach, and we do civil litigation and criminal defense. I primarily do civil litigation and personal injury, and I do a lot of DUI defense and lower misdemeanor defense.
All right. And Tyler Silvestro is here with us as well from the Chambers Law Firm. And in addition to criminal defense, what does Chambers work with?
We're primarily criminal defense. We also do some auto accidents.
All right.
Your typical personal injury.
So we're well equipped to answer all your questions as far as criminal law is today. Like I said, all aspects, whether it's specific charges or just the law system, the legal system in general, we can answer and talk about all those questions and topics here today. Again, the phone number's on your screen. Don't wait to the very last minute to try to get your call in. Call us now, 848-8080 is the phone number. Now, we normally have somebody here from the solicitor's office. We don't today, but usually we'll talk about the fact that there's a lot of plea bargains because of the fact that there are so many cases for the 15th Circuit, which is Horry and Georgetown counties. And because of that, they have to do a lot of pleas. Now, as defense attorneys, do you use that to your advantage, knowing that they don't have enough time to take all the cases to court so that you can get some sort of a good plea deal for your clients?
Yeah, absolutely. I mean, it depends on the situation, of course. Some cases we're certainly looking to have tried. Some cases are going to usually result in a better result on a plea bargain. Of course, it depends on the facts, the situation, and the client's goals. But they can be very helpful for us.
Yeah, I mean, it's going to be impossible for the solicitor's office to try every case on every charge. So oftentimes, a defense attorney is working with a prosecutor to try to get the best result for their client, and 99 times out of 100, it's probably going to end up being some sort of plea.
Right. When we talk about criminal law, often we talk about the fact that there's no jury selection process in the state of South Carolina like they have in a lot of other states. Do you find that to be an advantage or a disadvantage as far as defense is concerned?
I think a disadvantage. Yeah, I think the more information from a defense perspective that you have on your jurors is going to be helpful. Now, I think that someone from the solicitor's office, a prosecutor, would probably say the same thing, because, to the best of your ability, you're looking for people you think would be, good jurors for your case, your client.
It is very difficult to tell who you're going to end up with the system that we have in South Carolina. So it's, to some extent, the luck of the draw. You try to feel out as many people as you can, but we don't have as thorough a process as a lot of other states. So
not the voir dire that there is in other states.
Exactly.
You get a look at them, you know what they did or retired from, whether they're married, what their spouse did or retired from. That's really about all you get.
So you get specific questions that you can kind of give to the judge in advance and saying, hey, if anybody here knows blah, 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 or if they've been involved with this, we'd like to excuse them. But other than that, you don't have, you have 12 strikes to strike this many people off the jury pool.
You get strikes, but you're just limited, as a matter of practice, how many questions and what you get to really know about the potential jurors. Mm-hmm. Whereas in other jurisdictions, there's a lot more leeway to find out a lot more information.
Speaking of jurors, a lot of people, as soon as they get their jury duty notice in the mail, they just freak out. They're like, I got to get out of this every way I can. I mean, is jury duty so bad that everybody needs to get out of it?
It's, people don't want to be disrupted, and people are busy and have things they want to do. I get it. It's a very important process, though. I, for one, would love to serve on a jury, maybe for my own self-interest, just to kind of get a peek behind the curtain, because I don't think I've even been noticed to serve at all.
It also depends on the kind of case, which you wouldn't know when you're going in, when you get that notice, what type of case you have. Some of them can be a lot of fun for some jurors, and some of them can be very dry and boring. It really depends on what you end up having on that docket.
As defense attorneys, do you ever get a chance to talk to the jurors or the jury pool afterwards to say, hey, this was my case, and what did you like or not like about how it was presented?
Yeah, I try to make a point after every trial to do that, because you learn so much, and they will bring up things that you might think are some small, minute point, but made a big difference to them. So it's always, I think, beneficial to get that perspective.
I found it's always very interesting to see what some of those jurors stuck on, because it's not always what you would be thinking on either side as prosecution, defense.
Right.
So it is very helpful for future cases to kind of see what jurors and the common person is thinking in that context.
And while the trial is ongoing, do you get a sense of how it's going by looking at the jury and how they're reacting to you and how they're looking at you or looking at the defendant?
I find that usually you kind of know where one or two of those jurors are with the case. Some of the more expressive ones, but no, I mean, it's always sort of nerve-wracking when the jury's out, because it's you never know what they're saying or doing back there.
It is a mystery.
Yeah. And while the jury's out, we've been seeing on TV all the time that, hey, they came back in 90 minutes, so that's going to mean it's a snap decision for one side or the other. Do you seem like the time that they're deciding guilty or not guilty, does that make any difference as really what kind of decision they're going to be making?
I guess it depends on the case and sort of how you feel the case went. If you feel like the case was very one-sided and it's an easy decision for the jury, you kind of want to see them come back early.
Right.
If there are some issues in the case and they're coming back really early as a defense attorney, maybe it's not the best feeling.
It's a perfect way to put it. Realistically, it can get nerve-wracking the longer they're out. But if it was a very tit-for-tat case and they come back quickly, you get a little bit nervous as to what's going on in that back room.
Tell you what, we're going to run to a break here real quick. When we get back, we'd love to get your phone calls. Criminal law is our topic here today. If you have any specific questions about specific charges, we'd love to be able to help you out there. And also the legal system in general, as we've been talking about for the last 10 minutes. We'd love to get your take on some of those aspects as well. Give us a call. The number is on your screen, 843-848-8080. Criminal law, our topic here today. It's Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access, brought to you by the McGuire Law Firm. Criminal law is our topic here today. Again, specifics like DUI, drug charges, anything else, fair game here today. We'd love to hear your questions and get those answered for you, or also the legal system in general. If you have any questions about bails, plea bargains, bond, anything like that, jury duty, please, again, feel free to give us a call. 848-8080 is our phone number. Speaking of juries, as we've been talking about for the last 10 minutes, I know that some states and in some instances you don't have to have a unanimous decision. I know in the state of South Carolina and in most of other states you do. I mean, even the Supreme Court doesn't need a unanimous decision to come to a choice. Do you think that something like that will ever change where, if you get at least 10 voting one way or 9 voting one way or a majority?
I would say from the defense side, I hope it doesn't change. I mean, you do need a unanimous decision for either guilty or not guilty.
Right.
But if you have, for example, one person saying not guilty, the rest are saying guilty, you get a hung jury. It can get retried, but the state only has so many resources to retry those cases, so it's helpful to the defense. I do appreciate it.
Yeah, I would hope that wouldn't be something that would change on the criminal law side.
Also, I've seen in other states where they don't have 12 jurors, they might have 8 or less, or it just depends. Do you think there's any chance something like that would ever happen in South Carolina?
Well, we actually have 6 jurors on our magistrate and municipal court juries, where you have 12 in general session. So we do have a smaller jury pool in some of our courts here, local courts.
Now, I know that you guys work with DUI cases as well. Like I said, if you have any questions about DUI, please feel free to give us a call. Now, I know that, again, in other states, a lot of times they'll have the breathalyzer that you can give while you're out in the field. In South Carolina, you have to bring them back into the station to administer the breathalyzer. Do you think that's it's fair to be able to bring them back and do that, or because if they refuse while you're in the field and they're like, no, I don't want to ride back with you and give you a breathalyzer, then you're already the one strike against you as far as ramifications go.
It's an interesting question. Here in South Carolina, you are placed under arrest prior to being given that opportunity to provide a breath, blood, or urine sample. So especially there are cases where if an officer smells alcohol, they're getting some indications, even if a defendant says, I'm not doing the field sobriety tests. They're going to take that into account, still place you under arrest 9 times out of 10, take you to jail, and see if you'll offer a breath sample. It would be very interesting to have a roadside test. I don't know how helpful that would be, interestingly enough. I mean, my understanding is some of those can be a little bit inaccurate, where they still would get you back to an actual breath testing site in those states that do have the roadside. So I'm not too familiar with the complications or potential complications with the roadside test, not practicing outside of South Carolina. But it could potentially be interesting for some folks that really did just have that one drink with dinner and avoid an arrest later.
Right.
Right. I think the big argument in favor of the data master, and which is the machine that they would take you back to the station or the data master room to provide a breath sample or offer you the opportunity to provide a breath sample, is that it is more accurate and those sorts of things, and maybe not have some of the problems that some of the roadside tests might have. But as Tyler said, you're placed under arrest before you're given that opportunity. So would it be good to have a way to weed out some of these people that aren't actually under the influence before they're under arrest
Right.
and taken to a station? I think it could be. I think it comes down to how it would actually work in practice.
Now, as far as DUI is concerned, I know that, and I forgot what my question was going to be, and I'll get back to that. Let's go ahead and ask, since you guys are defense attorneys, I usually ask when we do a DUI show as far as your advice. If you're sitting around with a bunch of people either on the golf course or in a cocktail party, and they come up to you and say, oh, you're an attorney. If I get pulled over for DUI, should I blow or not blow, going back to the breathalyzer? What's your advice?
Well, it's always difficult because it's situational, but if you give the general advice, I would say if you've had anything to drink, you're not going to want to blow.
Yeah, I would agree with that. It's hard. It is situational. If you had one glass of wine and it might be in your, at that point, I'm probably in your best interest to blow.
Yeah.
But if I'm giving just general advice, this is the general rule, it would be don't if you've had anything to
Right.
drink. Yeah.
It's also difficult to tell if you have had a couple of drinks where you might be. So again, general rule, probably not going to blow if you've had anything to drink at all.
Speaking of DUI still, there's a lot of people on the prosecution side that have said that there's way too many loopholes in the DUI laws, that the way they're written, at least in the state of South Carolina, whereas the statute is several pages long, and the example they always give is like the statute for homicide is like 2 paragraphs, but for DUI you have to follow everything to the letter to be able to get a conviction. Was that, since there are so many lawyers in Columbia writing laws, was that written on purpose that way to be able to make it tougher to get a conviction on DUI, or what?
I don't think it was purposely to make it tougher to get a DUI conviction. I think, if anything, they just wanted to have less subjective standards. A lot of that stuff is geared toward getting the subjectivity out of the situation, because officers on the roadside, they're having to make a decision in the moment as to whether they think this person's intoxicated, and then if so, are they materially and appreciably impaired. That's why they do field sobriety tests, and it can be difficult for an officer to be able to go into court and tell a jury what they thought if there wasn't any video,
Yeah.
right? So just having the videotaping statutes and that the video having to start no later than the blue lights come on, I think those are all very important things to get a jury that might potentially hear a case a more objective view of what actually occurred and make their own judgments.
Right. That's not having the video would be a big deal. So before you have this statute that requires these things be video recorded, you've got an officer, going into court and giving his side of the story, and he's wearing his badge and his uniform, and you've got a defendant over there that's got doesn't really have the resources or any material he can offer to refute those statements. So I think the videotaping statute is very, important. And quite frankly, some of the teeth have been cut out of that statute, I feel, lately with some of this case law that's come down
That is right.
It's, so I don't think it's unfair. Maybe it could be cleaned up. Maybe it doesn't need to be as many pages as it is. But in practice, I think it's protects the citizens.
We're talking about criminal law here today. That's our topic. Again, the phone number is on your screen if you have any questions about specific laws, or if you have any questions about just the legal system as a whole. We'll be able to answer those for you here today. Again, 848-8080 is our phone number. The number's on your screen. And I watch a lot of crime shows, and if they take somebody in for an interview in the police department, whether or not they're a suspect or a witness or whatever the case may be, a lot of times if they refuse to answer questions and ask for an attorney, they have a close-up of the cop that says, "Oh, well, they lawyered up," and you could tell that they think, well, they must be guilty of sin because they asked for an attorney. But what's your advice? I mean, if somebody is brought into the police station, whether they're a suspect, a person of interest, or a witness?
Lawyer up.
I second that 100%.
Yeah.
Yeah, they're I'm sure they are disappointed and they want to get information right then and there, but they don't have that person's interest at heart. So you have to protect your own interest and talk to a lawyer. And that doesn't mean you don't still provide statements, cooperate
Right.
with law enforcement, but it would be good to seek legal counsel before doing so.
Yeah, on the shows they always look right in the camera, and the dramatic music is on. It's like, yeah, they lawyered up, because they want you to think that, well, they're guilty because they lawyered up. Right. All right, well, I'll tell you what, we're going to run to another break here real quick, and when we get back, we still have time to get you on the air. About 10 minutes left in the show. If you'd like to give us a call, criminal law is our topic here today, 848-8080. Don't make me ask all the questions. I'd like to hear from you as well. Give us a call, we'll get you on the air. It's Legal Access, brought to you by the McGuire Law Firm. It's Legal Access, brought to you by the McGuire Law Firm. Criminal law is our topic here today. You got still a little under 10 minutes to get you on the air. If you have any questions, general or specifically about criminal law, we'd love to hear from you and get your questions answered. The number's on your screen, 843-848-8080. Here on the panel today to answer those questions for us, we have Austin Thomas, also Tyler Silvestro. So, I'm inconsequential. I can't answer the questions here today. I'm just a TV host. All right, tell you what, some of the other things that we have questions in general about, we talked about lawyering up, and as far as being in there, polygraphs. Do they have polygraphs in the state of South Carolina?
They're not admissible
Right.
in court, but I have had, situations and colleagues that have used them to their advantage for negotiation purposes outside of introducing them as evidence in court. It's a little bit more rare, because again, you can't admit
Right.
that as evidence at trial, but they can come in handy.
Yeah, used oftentimes maybe more in the investigation phase.
Right.
I think a little less and less, just from my perspective. I think it was more common in the investigation phase, but certainly I've had clients that have used them and ended up not being charged, and with them not being admissible in court.
Right.
Sometimes it's not a bad idea to advise your client to go through that.
Well, that's kind of the next question, kind of like lawyering up when you're being interviewed. Would you advise people to take a polygraph or not take one if they're asked to do one when they come in, either as a witness or a person of interest?
I would say if the police are trying to ask them to do a polygraph, probably wouldn't advise them to go forward with that. That's something that I would probably talk to my client about, figure out a lot about their situation, what's going on with their case, and whether that might be beneficial to them in that situation, instead of just saying, yeah, if you're asked to do a polygraph, go ahead and do it. Why not?
Yeah, I think at that point, you're certainly at a point where you want to consult with a lawyer, because you're probably at a point where you're at a crossroads of whether they're going to charge or not charge, and an attorney might be able to help you out a lot in that situation and kind of give you the best advice for you.
We talked about at the very beginning of the show that plea bargains are very common, at least in this district, just because of the fact that there are so many cases and there's only so many days of the year where there's going to be an open court where you can have a case heard. If a plea, as defense attorneys, if a plea bargain is offered to you and your client, is that something that they have to go and talk to the family about, the family of the victim or the victim themselves if they're still alive, to say, hey, we want to give a plea bargain to this person and this is what we're offering them? Do they need any kind of approval from the victim or victim's family?
They don't, they need to notify them. You know, there's a victim bill of rights in South Carolina, and they have to communicate certain things to the victim or the victim's family, but it's not something where a victim or their family needs to sign off on. It's ultimately going to be the decision of the prosecutor's office.
As a matter of course, they're going to run those things by the
Right.
victim, but it's not necessarily the victim's choice to say yes or no, this is acceptable.
Right.
They could apply pressure, of course, but that's about it.
Now, as far as again, as defense attorneys, you have a lot of things at your disposal you can use depending upon what the charges are against your client. Youthful Offender Act and various other diversion programs like DUI court, do you guys utilize that quite a bit?
Yeah, oftentimes they can be helpful. The mental health court, the drug court, where they've sort of combined them, oftentimes are really good for everybody. They can you know, help your client, certain clients that might have some issues they're struggling through, to actually get them help and get them on the right path and get them through this without having a conviction on their record.
The diversion programs are very helpful to have, especially for either first-time offenders, like pretrial intervention, fantastic program to have. Allows you to kind of jump through hoops to show you're doing the right thing by society and be able to clean
Right.
some smaller charges off your record as a first-time offender. Those are very helpful. Just as was mentioned, treatment court. I've had a lot of clients say this was the best experience of my life because they've made significant changes through there. There are other people that don't do so well in those programs, so they can be harmful, but if you know your client and your client's up for the task, they can be a life-changing thing.
One of the questions we get a lot when we do criminal law or any kind of a show like that is expunging their records. What's the process of doing that, and what kind of offenses are able to be expunged from somebody's record?
Well, there are certain times where they're going to be expunged automatically if you're in a lower court and the case is dismissed, or you know the prosecutor ends up dismissing the case. It's something that's going to be done automatically. Oftentimes in general sessions, even on there's something called a conditional discharge plea, where you plead, sentencing is held in abeyance, and you have certain requirements you have to meet. And once you do, the case is dismissed, but you still have to apply for an expungement through the solicitor's office, and there'll be a little bit of a time period.
All right, we appreciate you watching here today as we've been talking about criminal law. We want to thank our panelists here today, Austin Thomas and also Tyler Silvestro. I'm Dave Priest. Next week when we get together, premises liability is going to be our topic. If you've been injured on somebody else's property, that's what that's all about. That's next Thursday, 11:30. If you have any questions about that, you can email us in advance if you'd like. I take that back. Thanksgiving is next week, so we'll be taking next week off. Hopefully you guys will as well. And we'll see you the week after that for premises liability. So anyway, legal access at WMBFnews.com is our email address if you'd like to email either about today's topic or next week's topic as well. We'll see you next time here on Legal Access, WMBF News.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by